You're watching LiveLaw and my name is Ostika Das. Welcome to another episode of Courts This Week, where we bring to you the most pertinent legal developments that took place last week across the country. Let us begin with two important developments in national politics. Congress leader Rahul Gandhi, who is currently embroiled in a controversy over his remark about Prime Minister Narendra Modi, was granted bail by a sessions court in Surat. Gandhi was convicted of criminal defamation on March 23rd by a magistrate court in the city and sentenced to 2 years simple imprisonment. The case was filed against Gandhi's "Why all thieves share the Modi surname" remark. His conviction in this case has led to his subsequent disqualification from the Lok Sabha. It is also important to note that the former Member of Parliament has challenged his conviction before the Surat Sessions Court. The Delhi High Court has denied bail to Aam Aadmi Party leader Satyendra Jain, citing the risk of evidence tampering. The former cabinet minister in the Arvind Kejriwal-led Delhi government was arrested by the Enforcement Directorate on money laundering charges under the Prevention of Money Laundering Act in May last year. Jain has been in custody since then. Justice Dinesh Kumar Sharma of the High Court refused Jain's bail application on the ground that he was an influential person and had the potential to tamper with evidence. The court said that the twin conditions under the Prevention of Money Laundering Act had not been satisfied. The most important story from the Supreme Court this week was the lifting of the ban on Malayalam news channel Media One. The Ministry of Information and Broadcasting had decided to not renew the broadcast license of the news channel on the grounds that it was anti-establishment and allegedly had links with Jamaat-e-Islami Hind. A bench of Chief Justice D.Y. Chandrachud and Justice Hema Kohli categorically stated that the channel could not be denied security clearance on the ground that it was critical of the ruling dispensation, nor on the basis of the alleged links of its shareholders with Jamaat-e-Islami Hind when it was not even a banned organization. The court also said that in any event there was no material to establish such a link. While allowing Media One's challenge against the Broadcasting Ministry's order, the court explained that this restriction on the freedom of press, which was protected under Article 19(1)(a), was not reasonable as per Article 19(2) of the Constitution. The court also made a very relevant remark on press freedom. It said, and I quote, "The critical views of the channel media, one on policies of the government, cannot be termed anti-establishment. The use of such a terminology in itself represents an expectation that the press must support the establishment. The action of the ministry by denying the security clearance to a media channel on the basis of the views which the channel is constitutionally entitled to hold produces a chilling effect on free speech and particularly on press freedom." Besides this, the court also pulled up the state for throwing around the term national security. The bench said that the central government had made no attempts to explain how the non-disclosure of certain information would be in the interest of national security. The bench said, and I quote, "Judicial review would not be excluded because of a mere mention of the phrase national security. The state is using national security as a tool to deny citizens remedies that are provided under the law. This is not compatible with the rule of law." In the same judgment, the Supreme Court has also held that sealed cover procedure infringed the principles of natural justice and open justice. In this case, the channel was kept in the dark about the reasons for withholding its security clearance, even as the Home Ministry informed the High Court of the reasons through documents submitted in a sealed cover. The top court observed that the sealed cover procedure had rendered the appellant's remedies meaningless. After making this observation, the bench led by Chief Justice D.Y. Chandrachud also devised a public interest immunity claim procedure as an alternative to the sealed cover procedure. The court explained that even in cases where the non-disclosure of information was justifiable on national security grounds. It was imperative to adopt a less restrictive procedure to do away with the culture of secrecy and opaqueness. So what is this sealed cover procedure? We've discussed that at length in another video, the link to which has been provided below. The Supreme Court refused to entertain a petition filed by 14 political parties alleging that central investigating agencies such as the Enforcement Directorate and the Central Bureau of Investigation are being weaponized by the union government to clamp down on dissent by arresting opposition leaders. The list of parties that approached the top court with this unprecedented plea included the Indian National Congress, Aam Aadmi Party, Trinamool Congress, the Uddhav Thackeray-led faction of Shiv Sena, Communist Party of India, Marxist, and many others. A division bench of Chief Justice D.Y. Chandrachud and Justice J.B. Pardiwala, however, refused to entertain this petition. The court said that in the absence of specific instances and facts, it could not use its writ jurisdiction to issue general directions. That, the court clarified, would be dangerous. The bench further said that political leaders cannot claim a higher immunity than ordinary citizens, and hence a special set of guidelines cannot be issued just for them. The Supreme Court issued notice in a contempt plea alleging non-compliance with its earlier order directing the government of Nagaland and the Nagaland State Election Commission to hold local body elections in the state. So what was this order? In March this year, the court was hearing a petition challenging the Nagaland Assembly's 2021 resolution exempting the operation of Part 9A of the Constitution. Part 9A contains provisions for local self-governance at the urban level and, among other things, mandates 33% reservation for women in municipalities and town councils of the state. While hearing this petition, the State Election Commission had informed the Apex Court that the local body elections in the state had been notified and were scheduled to take place on May 16. A bench of Justices Sanjay Kishan Kaul and Ahsanuddin Amanullah categorically said that the election schedule notified by the State Election Commission was not to be disturbed at any cost, which is why now they have served the state government as well as the State Election Commission with contempt notices. The Supreme Court of India refused to entertain a petition challenging the Maharashtra government's decision to rename Aurangabad city as Chhatrapati Sambhajinagar, as a similar matter is pending before the Bombay High Court. The matter was heard by a bench of Chief Justice D.Y. Chandrachud and J.B. Pardiwala. 2 weeks ago, another petition seeking intervention in the Maharashtra government's decision was also turned back by the top court since the Bombay High Court has already taken cognizance of it. Maharashtra's Aurangabad city derives its name from the Mughal Emperor Aurangzeb. The Supreme Court refused to issue a stay on the proposed expansion plan of a waste-to-energy plant in Delhi's Okhla from 23 megawatts to 40 megawatts. After the project developer Jindal ITF Urban Infrastructure Limited told the bench that the process of expansion and operationalization of the plant to the enhanced capacities would take about 18 months, a bench of Chief Justice D.Y. Chandrachud and Justice J.B. Pardiwala observed that it was unnecessary to consider a stay application at this stage. However, even as the bench allowed the plant to enhance its processing capacity, Chief Justice Chandrachud clarified that any step towards implementing the Environment Ministry's permission would not be protected on equitable grounds. The main civil appeal, which has been pending for the last 5 years before the top court, is a challenge against a National Green Tribunal verdict allowing the incineration plant to continue running despite opposition from local residents, nature conservationists and waste pickers unions. In a significant judgment on taxation law, the Supreme Court held that an amendment brought to Section 153C of the Income Tax Act in 2015 would retrospectively apply to searches conducted prior to the date of the amendment. Section 153C allows the Revenue Department to proceed against a party other than the person who is being searched if incriminating articles against that other person is found during the search. The issue in the present batch of appeals before the Supreme Court was whether the amendment would apply to searches undertaken before 2015. And a bench of Justices M.R. Shah and C.T. Ravikumar said yes, the amendment would retrospectively apply before the date on which it was passed. The Supreme Court orally asked lawyer and BJP spokesperson Prashant Umrao Patel to tender an apology. Who is Prashant Umrao Patel and why has he been asked to apologize? Patel came under the scanner earlier this year for his tweets claiming that 15 migrant workers were assaulted in Tamil Nadu for speaking Hindi, of which 12 died. Last month, videos of migrant workers allegedly being attacked in the southern state were being shared on social media. They were eventually debunked as fake by fact-checkers and the state police department, but not before causing widespread panic. Patel was booked by the Thoothukudi Central Police for allegedly spreading wrong information and promoting enmity between different groups. While granting him anticipatory bail, the Madras High Court asked him to, among other things, report to the police station between 10:30 a.m. to 5:30 p.m. every day for 15 days. It was against these conditions that Patel had come up before the top court in appeal. A bench of Justices B.R. Gavai and Pankaj Mithal agreed to modify the bail condition and directed Patel to report to the police station on Monday at 10 a.m. and after that as and when required by the investigating officer. After pronouncing this order, the bench also orally instructed Patel to tender an apology for spreading misinformation. The bench said that he should have been more careful, especially because he is a lawyer. The Supreme Court directed all states and union territories to adopt the guidelines on forced hysterectomies prepared by the Ministry of Health and Family Welfare within 3 months. With this direction, the top court disposed of a PIL petition in which the petitioner had claimed that illegal and forced hysterectomies were being performed on women living below the poverty line in the states of Bihar, Chhattisgarh and Rajasthan, so that the hospitals could rake in high insurance fees from the government under various health insurance schemes. Additional Solicitor General Aishwarya Bhati told the bench that the government had proposed a very strong and robust mechanism for monitoring and evaluation in these guidelines. She said that the centre's action plan to tackle this problem included the inauguration of a grievance portal as well as the creation of national, state and district level hysterectomy monitoring committees to regulate hysterectomies, especially with respect to women below the age of 40. Thank you and keep watching Courts This Week for more such updates. Once again, if you found this video useful, don't forget to like, share and subscribe. Hit the bell icon to get notifications and visit our website www.livelawlaw.in for the detailed reports. I'll see you again next time.